Good afternoon. Good afternoon. I'm Judge John, retired Circuit Court Judge in Milwaukee County, and on behalf of the Milwaukee Bar Association and the Wisconsin Justice Initiative, I want to welcome you to the 2002 Supreme Court Judicial Forum. I want to start off by thanking the Wisconsin Justice Initiative, as well as the Milwaukee Bar Association, for sponsoring this forum. The Milwaukee Bar Association has been having judicial forums for the last 25, 30 years. They believe it's very important that the public have an opportunity to firsthand hear from candidates who are running in contested elections. I also want to thank the media outlets who are here today. It's really important that the public know. Public has a right to know. Public has that opportunity when media shows up at events such as this. I also want to thank the three candidates who are running for the Wisconsin Supreme Court this year. Incumbent Justice Daniel Kelly, Dane County Circuit Court Judge Jill Karofsky, and Marquette University Law Professor Ed Fallone. They're here today and to answer your questions. First of all, what I'd like to do is explain the format of this forum for those of you who are attending for your first time. Each candidate is going to be given 2 minutes to make an opening statement. The order has been determined earlier by a drawing. You will have an opportunity to submit written questions for the candidates. If you have a question, there's paper on the table. Fill it out, raise your hand. One of the staff members of the Milwaukee Bar Association will bring the question over to me. I will be vetting those questions. But I want you to know your questions have to be addressed to all the candidates. It's not to be addressed just to one candidate. It's a question for all the candidates. Your questions may be hard-hitting. That's fine, but they do have to be respectful. And as I indicated, I will vet them for their appropriateness. The mediator, who is Steve Walters, will select the questions that are going to be asked to the candidates, and the answers will be given by each of the candidates. At the conclusion, each candidate will be given 1 minute to make a closing remark. There will be a timekeeper here somewhere, there she is, who will let the candidates know when they have 30 seconds left and when they have 5 seconds left to speak. Mr. Walters, who is our moderator, will enforce these time limits. As I've indicated, our moderator is Steve Walters. He's a news reporter in the state for many years. He's covered state government for many years. He's currently the senior producer of the WisconsinEye. We are honored to have Steve with us here again. Please welcome Steve Walters.
Thank you all very much for coming. I really want to thank you. I want to thank the candidates. These are important forums. And without further ado, just a reminder, the primary election is February 18th. The general election is April 7th. And without further ado, the opening statements, as the judge indicated, chosen by lot. Our opening statement, first 2 minutes. Justice Kelly, please.
Thank you so much. And thank all of you for being here and everyone who's watching. It's great to spend a little bit of time with you to talk about the court and our judicial philosophies. As you know, I was appointed to the court in 2016, and it has been the honor of a lifetime to serve you on your Wisconsin Supreme Court. And what I've been trying to do since 2016 is pretty simple, and this defines my judicial philosophy and everything that I do on the court. It's about being faithful to the constitutional text. The text as it's written, not as we might wish it to be, but as it was actually adopted and maintained by the people of Wisconsin. It's about following the statutes and the legislative commands of what they ask us to do and comparing that to the Constitution. It is ultimately about being faithful to the people of Wisconsin. See, I understand that all the authority that I exercise on the Supreme Court of Wisconsin, none of it belongs to me. None of it. All of it belongs to you and the rest of our fellow Wisconsinites. It's simply a loan to us. And that loan is mediated through the Constitution that you created and that you maintain. And in that Constitution, it tells me that we are to exercise the judicial power, not the legislative, just the judicial. There's no mystery to that. That's just applying the law as it's written, as we receive it. The heavy lifting goes to the legislature. They decide what policies will contribute to human flourishing. They make the hard policy decisions. Once they're done, we simply apply that to our cases. And that's what I've been doing since 2016, and I can tell you that it has been an absolute joy. It incorporates the three best aspects of the practice of law: deep and thorough research, conversation with colleagues to get to the roots of the law, and writing about the law with precision and accuracy. And I'm here today because I'm asking for permission from my bosses, all 6 million of our fellow Wisconsinites, for permission to continue serving them on their Supreme Court for the next 10 years. Thank you.
Thank you. Judge Karofsky, please.
Good afternoon, everyone. Judge D'Amato, Steve, members of the Milwaukee Bar Association, thank you so much for hosting us today. Really, really appreciate it. I'm Jill Karofsky. I'm a judge. I'm running for the Wisconsin Supreme Court because we have got to get this court back on track. I have spent the past several months traveling all around Wisconsin, and I hear the same thing from voters. What they see on the Supreme Court are justices who do not follow the rule of law. They see justices who make decisions before anyone walks into the state Supreme Court chamber. They see justices who are more interested with protecting corporations than in protecting our air and our water and our planet from corporate pollution. They see justices who are acting like politicians, and all of that feels like corruption to people. So I am in this race to offer a very, very clear choice, and I am bringing three things to this race that I will bring to the Supreme Court. The first thing is my experience. I'm the only person sitting up here who is or who has ever been a trial court judge. I am in the courtroom every day. I presided over more than 1,700 cases last year. I see how the law impacts real people. I understand how important it is to apply the law fairly and equally and respectfully. And in applying a document like the Constitution, we have to do it with today in mind. It is 2020. Where I sit, I see that the law is not an esoteric exercise for victims of crime, for defendants of crime, for folks going through a divorce or an eviction action. It is not an esoteric exercise. We are there to solve real problems for people, and that is the experience that we need on the Supreme Court, someone who's been on the front line. I've also been a prosecutor, and I've also been a victim advocate. So I'm bringing my experience, I'm bringing my Wisconsin values, I'm bringing my energy to this race, and I'm going to bring those three things to the Supreme Court so that we can win back Wisconsin's seat on the court.
Thank you. Professor Fallone, please.
We have a choice this election for state Supreme Court. Voters around the state are frustrated. We get to April and the general election for our state Supreme Court, and they feel like they didn't have any say or choice in who the candidates are that they're presented with. I'm very proud of the fact that I've been running a campaign to give the voters of Wisconsin a true choice and a true difference on our state Supreme Court, because that's how we get the court back on track. I grew up in a working family. My father was a public school teacher. My mother was a Mexican immigrant who came to this country when she married my father. They raised 4 kids on a teacher's salary. I went to one of the top law schools in the country on an academic scholarship, and I practiced law at one of the best law firms in the country, one of the top law firms, practicing against top lawyers from around the country. And then I decided I didn't want to spend my life representing mega corporations. I wanted to give back to people like myself. And so I came to Wisconsin, and I've been teaching for 27 years at Marquette University Law School as a constitutional law professor. I've been giving back by leading nonprofit organizations that provide low-cost lawyers to working families stuck in the legal system. And this election, we have a choice. We can have a different kind of justice. I'm very proud not only to bring my expertise in constitutional law, which led Senator Herb Kohl to ask for my advice on 4 U.S. Supreme Court nominations, not only to have my experience standing shoulder to shoulder with working families in the legal system, not only having spoken out in defense of the rights of free speech of the Solidarity Singers, against the Muslim ban, and fighting against English-only laws over my career, but I would also be the first Latino on the state Supreme Court in our history. Folks, when I ran in 2013, over 360,000 Wisconsin voters voted for me. and felt that I was the voice they wanted to see on the state Supreme Court. And in 2020, we are ready for change on the court. Thank you.
Thank you. I will now ask each candidate, one question, and other candidates have 2 minutes to add any PS or follow up on that. I'll take turns asking. Let's talk about campaign finance first. Professor Fallone, WisconsinEye interviewed all three of your candidates. In that interview, you said if elected, you would bring back the proposal that if a justice's campaign received more than X amount, let's say $10,000, in donations from a litigant or an attorney in a pending case, that justice would have to withdraw from the case. The court rejected that once. Why do you think it's so important to bring that proposal back?
Well, I've been speaking out and fighting for reform of our recusal rules since I ran for the court almost 7 years ago. And since then, I've continued to speak out, and I've worked with Common Cause Wisconsin and other groups to do public education on this important issue. It's very simple. When a party leaves the courtroom having lost a case, they shouldn't have a question in their mind whether they lost on the merits or whether they lost because the opposing party or opposing counsel had made campaign contributions to the judge. That kind of doubt is toxic to our system. We have an excellent proposal that was rejected by the current justices on the court. It was a petition by 50 retired circuit court judges, and it simply said if the judge has received at the Supreme Court level in excess of $10,000 of contributions or indirect spending on their behalf, that judge is required to step down. It's a simple rule, it's easy to apply, and on day one as a justice, I'll begin advocating my colleagues, we need to make change.
Follow up, Judge Karofsky first, and then Justice Kelly.
We absolutely need a recusal rule in the state of Wisconsin. We need it for people who are running for the Supreme Court, for the Court of Appeals, and for the Circuit Court. Without it, people's confidence in the judiciary is eroded. We need to have a bright line rule. It's the only thing that's fair to voters, to candidates, to judges, to justices. And anyone who receives money above that line should not, from a certain party or a corporation or a person, should not be able to sit on that case. Now, the Supreme Court, when Justice Kelly was on the court, had the opportunity to hold a hearing in 2017 to get information so that they could make an informed decision, so that we could all have a rule that we could stand by. And Justice Kelly and the court didn't even have the hearing. They wouldn't even pull together the information so that the state of Wisconsin could have a recusal rule. Because without that rule, the only thing that keeps someone from sitting on a case, even though they have received lots and lots of money from a person or an organization, is if they just say, I don't want to do it. I'm just not going to do it. And that hasn't happened. So yes, we need a recusal rule. We need to have a hearing. We need a clear recusal rule. And I, for one, would be very, very happy to stand by that rule, to abide by that rule.
Justice Kelly, please.
Thank you. I'm always open to a reform of our Supreme Court rules, and in addition to the way we handle recusals and campaign finance. However, I'm not going to rush willy-nilly into a reform that has the potential for creating more political mischief than it solves. Here's the thing. Part of this is a question of the authority and responsibility of the people of Wisconsin. They've decided that $20,000 contributions are appropriate to Supreme Court candidates. And the proposals that I've seen have been second-guessing the wisdom of the people of Wisconsin. And frankly, I'd prefer to rely on the good sense of our fellow Wisconsinites than a couple of really motivated special interests in reforming our recusal rules. I'll always consider carefully the plans that are submitted to us. We did not give a hearing to the one presented by the retired judges, primarily because it was on its face completely unworkable. It created so many opportunities for political mischief that there is no way that we could have turned that into anything like a workable rule.
Professor Fallone has asked for 20 seconds to respond. Short response.
It's misleading to point to the $20,000 contribution limit in state law. This is not about donating to elect a judge. It's about being able to choose which judge sits on your case. That's a very different thing.
Okay. Next question. Subject is collegiality. If elected, how would you specifically work as one of 7 justices towards professional collegiality on the court? Judge Karofsky, this question goes to you first because in your opening statement you referred to all that feels like corruption.
Thank you. I would use the same consensus building skills that I've used my entire career. I had to use consensus building skills when I started out as an assistant district attorney and then a deputy district attorney in Dane County. I worked with public defenders, private bar attorneys, judges. I worked with victim advocates, probation agents to make sure that we solved some real problems that we were having in the Dane County court system. I used those skills when I was at the Wisconsin Department of Justice. I was the state's first violence against women resource prosecutor, and then I was the head of the Office of Crime Victim Services. And in my role as the head of the Crime Victim Services, I worked with prosecutors and defense attorneys and judges and justices and members of the public to craft a rule through the Judicial Council. You no longer see a victim's name in a Court of Appeals decision or a Supreme Court decision or a Court of Appeals brief or a Supreme Court brief because of a rule that I was able to get passed by building consensus, finding places where people could agree. It took over 2 years to get that rule drafted and passed, but we did it. And those are the skills I would use. I would find areas where we could agree. There are areas where we would agree to disagree, and then there is an incredibly huge gray area, the Venn diagram where both those circles overlap, where I would work to continue to build consensus like I have done my entire career.
Justice Kelly, on the collegiality question, please.
So I think probably the question grows out of some stories that we all read several years ago about some difficulties in the relationship between the members of the court. And when I joined the court in 2016, I was a little concerned about what I would find there. But I can tell you that I was pleased to find a court that was on the mend, and that the relationships were healing, and that they were working together as a collegial body better than I had been reading about in the newspapers. And I think that trend has continued. I see one of my colleagues here, Justice Dallett, so this is Milwaukee. She served as a Milwaukee Circuit Court judge here for many years, and so I'm assuming that most of you here know her. And if you do, you'll know this, and if you don't, I will tell you. She brings a level of energy and good cheer to the court that is just a pleasure, and she has a fine sense of humor, and so I've been enjoying my colleagues, and I think that the way that we work together on the bench and in conference has been what the people of Wisconsin have asked for from their Supreme Court justices, and that's been a pleasure, and I intend to continue doing that.
Professor?
I like Justice Dallett, too. I have extensive experience leading organizations and building consensus. As chair of the Marquette University Academic Senate, I led my colleagues in passing a unanimous resolution condemning our president when he withdrew a job offer from an openly lesbian job candidate. I worked at the Latino Community Center as president of the board to guide that organization through a public relations crisis and to lead the search for a new executive director and successfully guide the organization through that process. I have experience working on multiple boards, including the Board of Trustees of Catholic Charities, which oversaw a budget of over $7 million at the time. So I know how to build consensus, and the lessons I have learned in my career are, number one, you don't impugn the integrity of the people you're trying to work with. You don't accuse them of improper motivations. Number two, you need to build trust so that the individuals you're working with aren't afraid that in a future time you might stab them in the back or criticize them unfairly. And number three, you can't come to the table with a predetermined outcome. You have to be open-minded. You have to be willing to find consensus to make compromise. That's the approach I've exhibited over my career, over 25 years in the nonprofit sector and as a leader of multiple organizations. I am the one candidate in this race who has avoided an us versus them setting of teams. Who's on, which side are you on? I'm on the side of the voters of Wisconsin, and I want to get our Wisconsin Supreme Court back to its job, which is representing all of us.
Thank you.
Steve, I just want to join the Justice Dalit Love Fest if I can.
Oh, okay.
Okay. I just want to go on record, and I appreciate her endorsement very much. Thank you.
Well done.
Thank
Okay.
you.
Question 3 comes from a member of the
Well
audience.
played.
Thank you. I will ask it of Judge Kelly. It's his turn, excuse me. How important would precedent set by the court be to you as a justice? For example, the court just recently reversed what had been a fairly new court precedent on the inherent powers of the state superintendent of public instruction. That's one of 6 constitutional officers. Judge Kelly, please. Justice
Yeah.
Kelly.
So the role of precedent in the court, I think, it's a critical role, right? So we aim for stability in the law, and when we look at precedent, what we're looking at is the good work of courts that have come before us, and our presumption is that the court got it right the last time that addressed the question, and so it's a heavy presumption, but it is not a dispositive function. Our role is to say what the law is. It's not to propagate error, right? And so when a prior decision gets it wrong, it's demonstrably wrong. Our responsibility, our sworn oath, is to set that aside and follow what the law actually is. And we all know how important this actually is in practice, right? One of the clearest examples of the importance of overturning precedent is between the cases of Plessy versus Ferguson and Brown versus Board of Education. So the court originally looked at the Equal Protection Amendment and said that separating the races but treating them equally is just fine. That satisfies the terms of the Equal Protection Clause. Brown versus Board of Education came along, looked at that and said, that's just not right. That is not what the Equal Protection Clause requires. Now, if we had a slavish devotion to precedent, then we would have upheld, the United States Supreme Court would have upheld Plessy versus Ferguson. But they didn't, and for good reason, because Plessy got it wrong. And so I followed that same approach in dealing with precedents. It's extraordinarily important, and we assume that our prior courts got it right. But when it doesn't, our sworn duty is to set it aside in favor of what the law actually is.
Professor, your response?
We live under the Wisconsin Constitution, not Dan Kelly's Constitution. And Justice Kelly and I have a very profound disagreement on the role of precedent. He has said that if he believes a prior case was decided wrongly, that he feels he has an obligation to overturn it. I absolutely disagree. It is important for the court to recognize and respect prior precedent. It does create stability in the law, and more importantly, it helps the court avoid reopening political battles. When every prior precedent is fair game, when we talk about justices being confirmed to the U.S. Supreme Court, will they vote to overturn Roe versus Wade? When we talk about elections and whether justices will take a position overturning prior cases, we turn our selection of judges into a political fight. And that is bad for our country, and it's bad for Wisconsin. And so I absolutely understand. Settled cases are done. We move forward. In terms of Plessy versus Ferguson and Brown versus Board of Education, this is a great example of the strength of our Constitution. Under the Equal Protection Clause, all of us have a natural right to challenge differential treatment and to put the government to the test. Can you justify why I am treated differently than everyone else under the law? In Plessy, the court accepted the government's justification. Well, that's just the way it is. The races don't like to mix. By the time of Brown Board of Education, the court recognized that no longer held water. And it's the same thing that happened with gender equality and with marriage equality. Everyone has a right to challenge the government's justification for different treatment, and when those justifications no longer stand, then it is appropriate to overturn the precedent.
Justice Kelly, I'll give you a chance to respond after Judge Karofsky.
Yeah.
Thank you.
I think the Koshki case that you're talking about is a prime example of why voters in this state are concerned about corruption on the Supreme Court. And corruption on the Supreme Court and Dan Kelly's decisions on it. Look, the Koshky case, going from the Coyne case, which was decided in 2016, to the Koshky case, which was decided in 2019, is nothing like what happened to jurisprudence in the United States between Plessy versus Ferguson and Brown versus the Board of Education. That's like comparing apples to thumbnails. What happened in the first case was the Coyne case. That case was decided by the Supreme Court in 2016. 3 years later, in 2019, the Wisconsin Supreme Court reversed its ruling 180 degrees. And as Justice Ann Walsh Bradley said, the only thing that changed in those 3 years, was the makeup of the Supreme Court. When we don't follow precedent, it erodes stability. It erodes predictability in the legal system, in the justice system. Every single time that Justice Kelly has the opportunity to rule in favor of the right-wing special interests, of the Republicans, he does it every single time. And that is why people think that there is corruption on our Supreme Court. This case is a prime example.
Justice Kelly, 30-second response, please,
So
sir.
two things. First, between the Coyne and the Koshky cases, there was no precedent there. In the Coyne case, the lead opinion was written by one justice. Nobody joined it. No opinion got more than 3 votes. There was no rationale that explained what the holding was. So we were effectively writing on a clean slate. Now, Professor Fallone has a greater commitment to stare decisis, according to his own terms. That operates as a one-way ratchet away from the Supreme Court, away from the law. So every time the court makes a wrong decision, he says, with that philosophy, you can never go back and fix that. You have to stick with the error. So that approach to precedent is propagating error without ever an opportunity to come back to what the law actually requires. And I will say this, I don't have time to address it right now, but Jill Karofsky, you've been making this accusation about corruption since the day you started your campaign. And I'm here to tell you that is a disgusting slander, and it is beneath contempt. And I'll address that in substance this afternoon and demonstrate why that is completely ridiculous. And I object to it. I'm outraged by it. And I just want you to know I categorically reject it. And I'm not going to take it out back and throw it in the garbage where it belongs. And we'll deal with that in substance later.
Hope I get a chance to respond, Steve.
A few seconds, Your Honor.
This isn't Jill Karofsky coming up with this. These are voters who I am talking to across the state of Wisconsin. All you have to do is look at the decisions that Justice Kelly has made. And every single time he has the opportunity to rule in the favor of the right-wing special interest, he does it. There is no way that the law can always be on their side. There is no way. And that is what happens every single time that he has made a decision in these cases.
Okay, I have
false
20
and
seconds.
easily demonstrable that
I have 20 seconds. There is no voter in Wisconsin who wants to see this on our state Supreme Court. There is no voter in Wisconsin who is happy with the state Supreme Court that is divided into camps and arguing with each other.
Okay, moving on. Next question. The Journal Sentinel did a story looking at statements all 3 of you took on important issues: same-sex marriage, gun laws, abortion rights, Act 10. Don't these positions, even though some of them were taken before you became a justice or a judge, give groups litigating these issues specific reasons to request that you get off their pending cases? And Professor, I think it's your turn to go first, sir.
I'm always very careful in my public speaking in the campaign to confine myself to cases that have been completed. I feel very free, I'm a law professor, to disagree with the reasoning of completed cases. I avoid comment on any cases that are ongoing. I don't see, having expressed an opinion as to the strength or weakness of the reasoning in a prior case, I don't see how that in any way would require me to recuse myself from a future case arguing a different theory or a different factual scenario. Those are different situations. I think it's important to educate the public And I think Justice John Roberts of the U.S. Supreme Court recently gave a speech indicating it's important for our judges to educate the public about our constitutional system in their decisions. And that's something I'm trying to do as a candidate, and that's something that I would do as a justice on the state Supreme Court.
Judge, please.
I've been really open and honest about what my values are and the values that I would bring to the Supreme Court. I tell people all the time that I was born and raised in this state, that my mom was one of the first women mayors in the state of Wisconsin. My dad was a local pediatrician. They taught me the importance of public service, of caring for my community. I tell people I'm the single mom of 2 teenagers, one of whom got his driver's license last week. It's a little scary, but good. I tell people all the time that my kids and I all went to public schools. I thank public teachers every opportunity I get. We benefited from wonderful teachers. I talk to my kids about human rights and women's rights and civil rights and workers' rights. And when I talk to my kids about getting into this race and I ask them what their concerns are, they're concerned about gun violence in their schools. They're concerned about the climate crisis. They see corruption on the state and the federal level, and they're looking to the grown-ups in the room to do something about it. Those are my beliefs. Those are my values. I am the only person sitting up here who has been a judge and follows the rule of law every day. I'm the only person sitting up here who has a track record for following the rule of law. That's what happens in my courtroom. I rule against my personal beliefs and my political beliefs on a weekly, if not a daily basis. So I'm not afraid to be up here and say, look, these are what my personal views are, but when I put my robe on, I follow the rule of law every single day.
Justice Kelly, please.
So I think it's really important that people have confidence that no outside forces are going to influence the way that we rule on a case. And so I don't talk about political matters since I have been on the Supreme Court. Now, it is true that every member of the Supreme Court has political views. All the members of the Court of Appeals and all 240-plus circuit court judges all have political views. The question is what you do with them, right? So the responsibility of a justice is when you put on that black robe is to set aside your political views and your political preferences. And you simply apply the law as it exists. That's what I've been doing since 2016, and it's demonstrable that that's what I've been doing. I invite anyone in this room to read the opinions that I write. Now, I write them in a particular way, specifically so that you can be confident that the conclusions are required by the law and not by my personal preferences. So the way I write an opinion is I start with the premises, which are the laws applicable to the case, and then I use rigorous logic to move from those premises down to the conclusion. And when I get done, if there is an unbroken chain of logic connecting the premises to the conclusion, then you can be confident that the result is required by law and not by personal preference. If there's a break in the chain, that's when personal preferences sneak in. And so the process we have of writing opinions on the court is extraordinarily helpful. I draft the opinion, and I send it around to my colleagues, and they have an opportunity to comment on, identify any potential errors, any breaks in the logic. And then we go from there. And we make sure that when the decision is complete, when the opinion is published, that it has that unbroken chain of logic between premises and conclusions so the people of Wisconsin can be confident that their laws are being applied faithfully.
Thank you. Next question. These numbers come from the Wisconsin Democracy Campaign. Candidates for the Supreme Court spent $2.3 million in the 2018 election. Third-party groups spent an additional $2.8 million. Candidates in 2019 spent $3.6 million, and third-party groups spent $4.5 million. So all spending 2018, $5.1 million, all spending 2019, $8.1 million, an increase of 58%. My question, does this trend in $1 million, $2 million Supreme Court campaigns undermine the public trust? Are any of you asking that no third-party group run ads to try to help or hurt your campaign this year? Judge Karofsky, I think it's your turn to go first, please.
Well, I think the number's probably going to increase this year. I think that if you are a right-wing special interest group, that you are going to be all in for Dan Kelly. Listen to his answer on the last question. Voters in this state aren't going to fall for the empty rhetoric that Justice Kelly doesn't have any preordained beliefs when he is making decisions. His jurisprudence that just is not borne out in the decisions that he issues. And if you are a right-wing special interest group, if you are a corporation, you are going to be all in for him, and these numbers are going to skyrocket. I mean, it's a big issue in these cases, in these races, because it makes people feel like they do not have a voice. Like the money is going to come in and tell them who's going to be their next state Supreme Court justice. I think it is unfortunate. I think it is too bad. I think that is why that we know in this race that we need to have a strong grassroots campaign, and that is what we are building. We have had almost 2,500 individual contributions to our campaign. We have new people joining our campaign every single day. We're going to do this the old-fashioned way. We're going to roll up our sleeves. We're going to do this handshake by handshake, voter by voter, to win this seat back on the Wisconsin Supreme Court.
Justice Kelly, please.
Well, I would never do anything to dissuade anyone from exercising their First Amendment rights. This is part of the right and the duty and the responsibility of being part of we the people. You get to decide how much you want to talk and to whom you want to talk, and if it takes money for you to do that, that is your absolute right to do that. And I don't think it's appropriate for any member of the judiciary to suggest that you shouldn't. And so I would never dissuade anyone from participating and discussing this campaign, regardless of whether they want to support me or support my opponents. That's all fair game. Now, this idea...
Excuse me, Your Honor.
Pardon me?
Were you finished?
Not quite yet.
Sorry.
So, and I just want to push back again on this ridiculous notion that my decisions are preordained when I come into the courtroom. That's just false. That's a lie that you tell, and you tell it regularly, but it's a lie, and it's disgusting. And we know it's a lie because there is third-party independent verification that what you say is not true. There's a website run by a gentleman at Marquette University. It's called Scalstat Blog. He studies opinions of the Supreme Court in the areas in which he's interested. He studied my opinions in particular, and he's compared what I write and the opinions that I join. He compares those against what he knows in my politics to see if there's a correlation. His conclusion is there's no necessary correlation between my politics and the opinions that I write or join. And as a consequence of that, he calls me a maverick. And he calls me a maverick. He calls me a maverick because, Jill Karofsky, you're just flat out wrong.
Yeah.
Excuse me, these are the candidates, and we're trying to get them to address the issues, and it's the professor's term to respond.
Interesting in Justice Kelly's response and the way he talks about the First Amendment, because the United States Supreme Court has ruled that the First Amendment does not prevent the passage of state laws regulating campaign finance in the context of judicial elections, because judicial elections are different. And this is an example of Justice Kelly, again, wanting to remake the Constitution in accord with his beliefs and not in accord with precedent and the way it's been interpreted. Look, we have a situation where independent groups, interest groups, can approach a judge and say, how would you like to be on the Wisconsin Supreme Court? Does that sound good to you? If you're our candidate, we will write checks. We'll make sure you have ads on TV. We'll handle everything. We'll find campaign staff for you. It'll all be taken care of. All you have to do is agree to let you'll be our guy or our gal. And that's what happens oftentimes. And how do you prevent that? How do you prevent those groups from self-selecting who the candidates are going to be? You have to have candidates who are independent, who don't take any of the money, who refuse that help, who say, thank you very much, I will raise my own money, I will hire my own staff. I will not ask the Republican Party to help me collect nomination signatures, I will do that myself. That's how you get this influence out of the court. It's not easy to run statewide. It takes a lot of money. And obviously, if someone approaches you and says, if you're our person, don't worry, the money will come. I've actually heard at a speech at the Federalist Society in Milwaukee, an individual explained that in today's world, for judicial candidates, education and experience is not important anymore. It's loyalty. That's what gets support. That's what gets the nomination. That's what gets you the candidate. That's wrong, and I'm running a campaign to fight against that.
Justice Kelly, 20-second response.
Yeah, I think, Mr. Fallone, we need to make a distinction between the judiciary and the legislature and the different branches of campaign finance that the Supreme Court has spoken to. So when I say that I would never discourage anyone from exercising their First Amendment rights, I mean that. I would never do that. Now, that doesn't mean that there isn't room for a legislature to step in and have something to say. Now, they need to be careful, of course, in the way that they legislate in this area, because it is such a profoundly important right that the Constitution protects. So the United States Supreme Court has made a clear distinction between contributions and expenditures. And I was not referring to contributions, which the Supreme Court has said can be regulated. I was referring to expenditures. The United States Supreme Court has referred to that as speech, and has said that people can speak as much as they want. And so that's why I say I would never discourage anyone, for or against me, from speaking their mind.
Next question comes from the audience. Thank you. How do you apply the law when there is no clear textual answer? How do you decide the, quote, gray areas? Justice Kelly, it's your turn to go first, sir.
That's a great question. So we have a rich common law tradition that we draw from our prior association with the British Empire. We imported that common law tradition into the United States, and that is the base of our jurisprudential system. The statutes are added to that. The statutes can add to it, detract from the common law, change it, supplant it. But ultimately, what we are trying to accomplish is determine what the statute means. And so far, as long as I have been on the Supreme Court, I've never had a circumstance yet where we haven't been able to determine what the statute means by looking at the text. Now, I refer to myself as a constitutional textualist, and that means that we look at the original public meaning of the words adopted either by the people of Wisconsin or their legislators in creating their laws. And we look at that meaning at the time that they adopted it. So we make sure that we're not reading back into history our current understanding of particular words and phrases. And if you use that process and you are faithful to it, generally speaking, there won't be any difficulty figuring out what the text means. Now, conceptually, could a legislature write a law that is so impenetrable that no one can figure out from the text what it means? Yeah, that's conceptually possible. But in that circumstance, our responsibility is to respond to it as Justice Gorsuch recently did when he was referring to a congressional enactment, and he said, our job is not to create meaning out of impenetrable words. Our job in that circumstance is to send it back to the legislature and say, you failed to make a law.
Professor.
Steve, can I get a clarification? Justice Kelly's answer bounced back and forth between interpreting statutes and interpreting the Constitution. Did the question make a distinction?
How do you apply the law when there is no clear textual answer? How do you decide the, quote, gray areas, sir? Okay.
Well, I'll address the constitutional question. I'm a constitutional law professor, home field advantage. The thing about the Constitution, I think of myself as an independent thinker. Many of these forums, we get questions, what's your judicial philosophy? And I always say, I don't have a judicial philosophy. I think one thing I've learned studying, writing about, teaching the Constitution over a quarter century is that there is no one theory that tells you in advance, just follow this procedure. Here's the instruction manual. Here's how you figure out the constitutional meaning if it's not spelled out in the gray areas. There is no one approach. A judge that I respect very much, J. Harvey Wilkinson on the Fourth Circuit U.S. Court of Appeals, wrote a book, Cosmic Constitutional Theory. I recommend it to everyone watching and everyone here. He goes through originalism, the evolving Constitution, various other theories, and he concludes they can all be misused. They can all provide cover for a judge who is outcome determined and wants to get to a certain point and simply wants to camouflage what they're doing. And I think that's the danger of being too tied to a particular theory. And his conclusion, and the one I share, and the one I talk about in this campaign, is that what's most important when interpreting our Constitution is a sense of humility, a sense that you don't have all the answers as a judge, that you haven't already figured it out. You should be open-minded. You should listen to the parties in front of you, and you should be humble enough to recognize you don't have all the answers. And that's the kind of judge I'll be.
Judge.
As the person in this race who has the most frontline experience as a prosecutor and as a trial court judge, it is difficult sometimes to figure out what the right answer is. Sometimes I have to do it many, many times in a day. You need to look at the law, you need to look at the precedent, you need to look at the facts, you need to apply the law to the facts, following the rule of law in a way that is fair and that is impartial and that is respectful to everyone in the courtroom. When Justice Kelly talks about his rigorous logic, what he is talking about is that he is getting to a predetermined outcome. And he can be up here and he can scold me and he can raise his voice. I'm not going anywhere. The voters in this state want their seat on the Supreme Court back. They want a justice who will follow the rule of law. I have spent my entire career fighting for justice, whether it was on the district attorney's office, helping women and children and people in need who were victims of crime, or whether it was at the Wisconsin Department of Justice, making sure that victims in every single corner of this state got the help and the support and the services that they needed. I've had to stand up and listen to people scold me and yell at me, and it does not make me back down. This race is too important. The stakes in this race are too important. Who we have making decisions on our Supreme Court is too important. And that's what this race is all about. Are we going to have a justice who has a track record for following the rule of law, or are we going to have a justice who has a track record for always finding in favor of the people who got him on the court in the first place and are going to work like crazy to keep him on the court?
Short response, Justice Kelly.
Thank you. So when I refer to rigorous logic, that is the exact opposite of what Judge Karofsky just said. Rigorous logic does not know conclusions. It knows process. The reason I use that process is because I don't come to cases with a predetermined outcome. The point of adjudicating is to take the law applicable to the case, use the logic, and follow it where it goes. That has been my commitment since 2016, and I challenge you to identify any logical error in any of the opinions that I've written. You won't find any. We've put them through the fire before we release them to the public. Each one of them has an unbroken chain of logic that demonstrates that what you just accused me of is just false.
Next question involves a concept called the civil Gideon. It is the idea that low-income individuals who were involved in civil court actions for evictions or child custody, child support, should be entitled to a court-appointed attorney. I want to ask our candidates if they support it, and if they do support it, how would they pay for it? Professor, it's your turn to go first.
Well, Steve, and as you know, and many people in the audience know, I've been fighting for access to justice in our legal system my entire career. I've been passionate about making sure that working families don't have to go to the courthouse alone, that they can get access to affordable lawyers to go with them in civil cases like divorce, landlord-tenant, or misdemeanor cases, or immigration cases. And I've led nonprofit organizations that provide lawyers to individuals doing that. And I was a trustee on the Wisconsin Trust Account Foundation, which gave grants and awards to organizations providing access to justice. So this is an issue I've been fighting for my whole career. The specific solution of civil Gideon, providing free representation at state expense to individuals who can't afford lawyers in civil cases, is perhaps an attempt to address the entire problem. And it would be certainly very expensive. And I've resisted coming out in favor of civil Gideon because I think there's a lot we can do up to, but not quite going that far. And so what I want to see is, as a justice, addressing what the court can do as the supervisory authority over our court system. Issues like, in our rural communities, it's very hard to find any lawyers, much less affordable lawyers. We have a crisis. I'd like to see our state Supreme Court take the lead in working so that, distance representation by conference call or by television closed circuit can be used to bring in where the lawyers are affordable and present, bring them out to the rural areas through the use of technology in our courthouses. I'd like to see us expand efforts in that direction. And there are other steps our court can take, because it's our Supreme Court's job to make sure in our justice system, people's justice, the quality of justice, does not depend on how much money they have.
Thank you. Judge, your turn.
I think the Supreme Court needs to do everything it can to make sure that the third branch of government is working. As someone who presides over injunction hearings and eviction actions, as someone who watches victims in court oftentimes struggle to figure out what's going on, having representation in those cases is hugely, hugely important. I started out by saying this, and I'm going to say this again, that the experience that I have watching how the law impacts real people is hugely important when you think about who you're going to have on the Supreme Court. Because I see how difficult, how confusing it is for people who walk into the courthouse. And I agree with Professor Fallone. This is at an alarming rate in the rural communities. And for civil Gideon, but also in criminal cases as well. I get emails, as I know several other judges do who are in this room, from rural areas in this state where they can't find public defenders or even people from the private bar to represent defendants in criminal cases. And oftentimes these defendants are just sitting in jail until they can find them an attorney, and it is weeks and weeks and weeks only because we can't find someone to represent them. So yes, I do think that the Supreme Court needs to take a leadership role. Since I have a couple of seconds, I just want to respond to Justice Kelly saying that I don't have any examples of him always finding for the right-wing special interests, and that's not true. The Koshke case is a prime example. The lame duck case is an example where the Supreme Court couldn't even wait to get their hands on that case to make a ruling. They plucked it from the Circuit Court before the Circuit Court could even hold a hearing on it. And they did it in the budget veto case again. And no one is going to be surprised by how Justice Kelly rules on those cases. They pulled them from the Circuit Court so that they could make the decision that they want to make as soon as they possibly could.
Justice Kelly, on civil Gideon, or in response to what was just said, sir?
Yeah, I would love to address civil Gideon, but I think we really do have to take Judge Karofsky to task for this disgusting slander, not just on me, but on my colleagues as well. I have never had my honor or my integrity called into question, ever, in the depth and breadth of the practice of law that I've done over the last 25 years, until now when it suits your political ambition. And I think that tells everyone all that we need to know about that slander. This is about your personal advancement, and you don't care who you're going to lie about to get there. But that's really not even the worst of it. I mean, I am deeply offended that you would say those kinds of scurrilous things about me, but that's not the worst of it. The worst of it is you can't even be bothered to keep your insults focused on me. So here you come and say that the court is acting in a corrupt function. I'll remind you there are 7 members of the court, and that means any decision taken by our court requires the agreement of at least 4 of the members. And that means that in any decision in which I've taken a part, that means I'm agreeing with at least 3 of my colleagues. And unless I miss my mark, the cases that you're referring to have all involved Chief Justice Pat Roggensack. And so what you say of me, if that's true, then it must be true of her as well. And that is an outrageous slander on someone who has been a paragon of integrity for the entirety of her career in the practice of law and her service on the bench. Now, you owe me an apology for this disgusting slander. I don't think you'll get one, because if you didn't have slander, you wouldn't have a campaign. But you do owe Chief Justice Roggensack an apology. She's not here. She's not part of this campaign, and she did not ask to be slandered by some careless trial judge who can't even be bothered to keep her insults focused on the target. So this is your opportunity. Apologize to Chief Justice Roggensack right now.
And Kelly, I'm not going to be bullied by you.
I think that tells us everything that we need to know right now. She can't even be bothered to apologize to an institution, someone like Chief Justice Pat Roggensack, who no one questions her honor or her integrity. And for her political ambition, she's willing to insult and slander even Chief Justice Roggensack. And she's not even willing to apologize for that. And I think that tells you everything you need to know about Jill Karofsky. She does not have the judgment or the character to get anywhere near the Supreme Court.
Any short rebuttals or go to closing comments here? Judge, I just want to be fair. Give you a chance to respond or move to closing statements.
Thank you. This isn't Jill Karofsky. This is what the voters, the people in the state of Wisconsin are seeing. They are seeing decisions made on the Supreme Court before anyone ever walks into the state Supreme Court chamber. That isn't what justice is. Justice is when a judge looks at the law and a judge allows the facts to percolate in a trial court where I sit so that witnesses can answer questions, so that there can be a fair hearing, so that there is a process that is followed that everyone can see. That is what justice is. And then after that, the law is applied to the facts of the case, and that's how you reach the right answer. That is what people in the state of Wisconsin are asking for, and that is what they deserve.
Thank you. By lot, the order of closing statements has been chosen. Professor, you're going first, please.
There may be people in this room or watching who are happy or contented with the display that we've seen between my two opponents. There may be people around the state of Wisconsin who are happy to see our Supreme Court elections descend to this level. If there are, I've never met them. As I've gone around the state, what I hear again and again is thank you for trying to keep politics out of the race. Thank you for not talking in terms of our side, their side, my team, their team. Thank you for focusing on your principles. I have a 30-year career of standing up for what I believe in, standing up for our right of self-government, standing up for our right of free speech, and defending the Solidarity Singers in the Capitol, standing up for the rights of immigrants, and criticizing the Muslim ban and explaining why it was unconstitutional, fighting against English-only laws. A 30-year career of fighting for what is right. And people came to me and they said, Ed, will you run for state Supreme Court? We have only 7 seats. This is our chance to get your voice, your perspective, fighting for all of us on the court. And that's why I'm running.
Justice Kelly, your closing statement, sir.
Thank you. I thank the people of Wisconsin for their enthusiastic reception to our campaign, whether it's in gathering signatures in the events that they've requested that I come out and spend time with them, the encouragement that they've given me through this entire process. I thank them so much for that. I was asked a question a few years ago by an outstanding 13-year-old student. In the middle of the Supreme Court hearing room, he stood up and he looked me dead in the eye and he said, "Who's your boss?" Well, I told him that his parents were my boss and the rest of the students were my bosses too. And I told him in 5 years he'd be my boss because that's the way it works here in Wisconsin. All of you, the power to create and maintain your governments belongs to you. And you retain it and you only lend it to us through the Constitution to exercise on your behalf. And you ask us to be faithful to that grant of authority, to follow the constitutional text, to follow the statutory text, to allow your legislatures to make your laws for us. And they ask us only to be faithful in applying the law to resolve their cases. I've been doing that since 2016, and it truly has been the honor of a lifetime. So I'm here to stand before you and ask you to render your report card on me. Have I been a faithful servant to you? Have I been faithful in applying the constitutional text and the statute? And everywhere I go around the state, people tell me that I have been. And they're grateful that the members of the court concentrate on just following the law. And so, I ask for your permission to continue serving you for 10 more years on your Supreme Court. Thanks very much.
Judge, your closing statement, please.
Thank you. Thank you, everyone, for being here today. Look, I'm running because we have to get this court back on track. And what I am bringing to this race, what I will bring to the Supreme Court is a depth and a breadth of experience, my values, and energy of never, ever backing down. I have the depth and breadth of experience that neither of my opponents can touch. As a prosecutor, as a victim advocate, I have experience in the civil law. I was a law school professor at Wisconsin's only public law school, and as a trial court judge. I have handled thousands and thousands more cases than both of my opponents. I have been on the front lines of our legal system, standing up for what is right in this state for almost 30 years. I have never backed down. I am not going to back down in this race. The people of the state of Wisconsin deserve justice on their Supreme Court. And that is exactly what I am going to bring there. Thank you.
Thank you. Before Judge D'Amato dismisses us, just a reminder, the primary election, February 18th, process.
On behalf of the Wisconsin Justice Initiative and the Milwaukee Bar Association, I want to thank Steve Walters for moderating today's judicial forum. I want to thank the three candidates for being here today to answer the tough questions and to face all of you, the electorate. I also want to give a shout out and thank Katie Borowski and the Milwaukee Bar Association staff for taking a lot of work. I really want to thank everyone who came to this forum to be here, to attend. You show your interest in the state of Wisconsin. You show your interest in the Wisconsin Supreme Court. By being here, it gives you an opportunity to be face-to-face with, to hear the candidates, speak the words to you in this room. I remind you, Steve, the primary is February 18th. Spring election is April 7th. Mark your calendars. I believe early voting for the primary starts on Monday. But remember to vote. Remind your friends and your relatives to vote. This is your opportunity to participate in the elective process. I've also been asked to let you know there's another forum that's going to be here next Monday. It's going to be starting at noon. It's with respect to the Circuit Court Branch 5 here in Milwaukee County. The incumbent judge is Paul Dadinsky. The other two candidates are Attorney Zach Whitley and Attorney Brett Blow. That forum will be here on Monday. I've also been asked to remind the lawyers in the room that the 2020 Judges Night is going to be this coming Tuesday, 5:30 p.m. at the Grain Exchange Building at 225 East Michigan. So once again, thank you for being here. Remember to vote.
Thank you, Steve.
Good to see you. Thank you. Good to see you.